Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review.
Hello everyone, this is Ed Ramos, Kevin's law partner at KKTP. I'll be covering for Kevin this week, rummaging through the decisions, so Kevin doesn't have to. We've got another week of straight losses for non-citizens, with decisions from the 11th, the BIA, and a big banc case from the 9th. Let's jump in.
Before getting to the cases, I wanted to talk a bit about Capital Good Fund. Millions of families seeking to improve their immigration status face financial barriers due to the high cost of legal services. Nonprofit Capital Good Fund is working to make these resources available to all, especially those who would not otherwise qualify for traditional loans. Certified CDFI Capital Good Fund is partnering with attorneys to provide the financial services that families need. They offer affordable financing with no closing fees or down payments for those working with attorneys to move their case forward and to get attorneys out of the accounts receivable business. To learn more about the program, email immigration@goodfund.us or call 866-584-3651. And tell them who sent you.
Our first case is Hasan-Nayem v. U.S. Attorney General, issued by the 11th Circuit on December 7, 2022. This case is about credibility. Mr. Hasan-Nayem is from Bangladesh. After being arrested at the border in 2019, he claimed a fear of members of the Awami League, the ruling political party in Bangladesh, and the actions of the police. He apparently told an asylum officer that he was threatened once and physically harmed 3 times in Bangladesh because he worked for the Liberal Democratic Party. He provided lots of details to both the asylum officer and the immigration judge, which I'll get to in a bit. Deemed to have a credible fear of persecution, he was placed in removal proceedings to bring his asylum claim before an IJ. In immigration court, Mr. Hasan-Nayem provided affidavits from family members, including his mother, father, sister, and friend, detailing some of the incidents of harm. Mr. Hasan-Nayem also submitted medical records showing severe injuries that he claimed lined up with beatings he received in Bangladesh due to his political activities. He also submitted country conditions evidence. The 11th Circuit opinion gives a pretty thorough play-by-play of Mr. Hasan-Nayem's evidence and testimony at the various stages of the administrative process. But because this case is about credibility, what's really important is how that evidence and testimony matched up. Mr. Hasan-Nayem's individual hearing appears to have gotten off to a bad start, because early on, the immigration judge told Mr. Hasan-Nayem to take off his jacket, suspecting that Mr. Hasan-Nayem was reading from notes he'd written on his sleeve or on his hands. He told his story of harm pretty consistently on direct, but, as the 11th Circuit tells it, his story didn't quite hold up on cross. Ultimately, the immigration judge issued an adverse credibility finding and denied relief and protection. To do so, the IJ dug pretty deep into the weeds to find inconsistencies and contradictions. The IJ also found that he had testified evasively, and that it wasn't plausible that a young low-level worker in the Liberal Democratic Party would be targeted and attacked so viciously by the Awami League supporters as Mr. Hasan-Nayem had testified to. And there were other problems according to the IJ. For example, Mr. Hasan-Nayem's medical records showed severe injuries to parts of Mr. Hasan-Nayem's body that Mr. Hasan-Nayem never mentioned in his testimony. On appeal, the BIA affirmed, finding that the IJ had properly found Mr. Hasan-Nayem not credible under a totality of the circumstances. The 11th Circuit, having by this point gone on for about 17 pages, did not disturb the agency's findings. True, an immigration judge can't make an adverse credibility finding without providing, quote, specific, cogent reasons for the finding, end quote. But here, the IJ and the BIA did so, and that finding, at least to the 11th, was supported by substantial evidence. It gets really detailed and fact-specific, but here's one example. Mr. Hasan-Nayem testified that he went to the police station following an attack in December 2018. In court, Mr. Hasan-Nayem said that his father and his friend accompanied him. But Mr. Hasan-Nayem's declaration mentioned only his father. His friend's declaration made no mention of his father, and his father's declaration didn't mention anyone at all accompanying Mr. Hasan-Nayem to the police station. Although Mr. Hasan-Nayem argued that there was no actual inconsistency, to the 11th, quote, the mere fact that the record may support a contrary conclusion, or that Hasan-Nayem has offered a tenable explanation for the inconsistencies, does not compel reversal, end quote. And really, this case was death by 1,000 cuts. Although there was hardly a smoking gun, no one seems to believe Mr. Hasan-Nayem, particularly as the IJ also made an adverse demeanor finding, believing that he simply memorized and recited his story. So in the end, Mr. Hasan-Nayem lost his case. And one reminder. Although not applicable here, if you ever have a case involving Bangladeshi political parties in the 11th, be sure to check out Islam v. DHS, episode 56 of the pod. That case discusses how both major political parties in Bangladesh, at least during certain time periods, could be considered to have offered material support of terrorism. What a world. And that was Hasan-Nayem v. U.S. Attorney General. Next is matter of Mariscal-Hernandez, issued by the BIA on December 9, 2022. This case is about suppression of evidence. Mr. Mariscal-Hernandez was arrested by ICE after leaving his apartment complex, which was under ICE surveillance as part of an operation targeting non-citizens with final orders of removal. According to ICE, Mr. Mariscal-Hernandez looked like one of their targets. So after Mr. Mariscal-Hernandez left the apartment and entered a car with his son, ICE stopped the car and began questioning the two. The first thing ICE did was to show the two a photo of the man they were targeting. Mr. Mariscal-Hernandez replied that he didn't know the guy. ICE then asked for ID. Mr. Mariscal's son produced a Mexican ID, but Mr. Mariscal-Hernandez himself didn't produce one. According to a Form I-213, essentially an ICE arrest report, both then admitted that they were unlawfully present in the United States. They were then arrested and put in removal proceedings. In removal proceedings, Mr. Mariscal-Hernandez moved to suppress the Form I-213, which ICE had submitted to prove alienage. Mr. Mariscal-Hernandez claimed that ICE had obtained the I-213 through egregious Fourth Amendment violations, specifically that ICE had stopped him without reasonable suspicion that he was unlawfully present in the U.S. He also claimed that DHS had violated his rights under the INA and binding regulations by conducting a warrantless arrest and by failing to advise him of his right against self-incrimination. Finally, he argued that even if admitted into evidence, the I-213 wasn't reliable and he should be allowed to cross-examine the arresting ICE officers. The IJ denied the motion, and the BIA affirmed. It began by noting that I-213s are generally probative evidence of removability. It's a bit of a strange doctrine because an I-213 is essentially an ICE arrest report, and it'd be pretty unthinkable in the criminal context, for example, for an arrest report to serve as evidence that a crime was actually committed. But it's pretty firmly entrenched in BIA case law, and the BIA wasn't about to revisit that case law here. There are exceptions, coercion for example, and some are discussed in the BIA's opinion. But no exception applied here. The BIA also rejected Mr. Mariscal-Hernandez's request to cross-examine the ICE officers, finding that he suffered no prejudice as a result. Having found that the I-213 was probative and established alienage, the BIA also declined to suppress it. Unlike in the criminal context, a straight Fourth Amendment violation doesn't support suppression in immigration proceedings. But the Supreme Court and BIA case law leave open the possibility of suppression in cases of egregious constitutional violations. Procedurally, suppression cases are decided under a burden-shifting framework set forth in a case called Matter of Barcenas. Under that framework, a non-citizen first has to make out a prima facie case for suppression. If successful, the burden then shifts to DHS to show that the evidence should be admitted. Here, though, the BIA held that Mr. Mariscal-Hernandez didn't make out a prima facie case. As to the constitutional basis for suppression, the BIA found that Mr. Mariscal-Hernandez failed to show a Fourth Amendment violation, let alone an egregious one. According to the BIA, ICE's initial stop was valid because it was undisputed that Mr. Mariscal-Hernandez looked like the non-citizen that ICE was targeting. He lived at the same apartment complex, and he had entered a vehicle and was about to drive away. In the BIA's words, quote, "The respondent's resemblance to the person the officers were seeking to arrest and his presence in the same location where this person resided are reasonable, articulable, objective facts justifying a brief investigatory stop." End quote. Of course, if ICE really thought that Mr. Mariscal-Hernandez was their target, why show him a picture of the guy? But the BIA doesn't discuss that issue. The BIA also found no violation of the INA and its implementing regulations. There's a pretty comprehensive set of rules at INA Section 287 and the regulations at 8 C.F.R. 287 that place various limits on ICE officers' arrest and detention authority. One section of the INA, Section 287A2, requires ICE to have a warrant before making an arrest, unless the person is, quote, likely to escape before the warrant is obtained, end quote. The BIA found that requirement satisfied here, in part because Mr. Mariscal was encountered while entering a vehicle, and therefore presumably was likely to escape before a warrant could be obtained. The BIA also rejected Mr. Mariscal-Hernandez's claim that ICE violated regulations by failing to advise him that any statements he might make could be used against him. BIA case law holds that any such advisals need only be made after a respondent is placed in removal proceedings. Because the I-213 was probative evidence of Mr. Mariscal-Hernandez's Mexican citizenship, and because the I-213 would not be suppressed, Mr. Mariscal-Hernandez lost his case. Two final points. The BIA notes that different circuits have different standards of what makes a Fourth Amendment violation egregious, and therefore able to support suppression in removal proceedings. The opinion goes through the case law in most circuits, so if you have a suppression case, give it a read to see what standard applies in your jurisdiction. Finally, in addition to all of the suppression stuff, there was apparently a defective NTA problem as well. Mr. Mariscal-Hernandez argued that his case should be terminated because the IJ lacked jurisdiction as a result. But the BIA threw more cold water on that argument. At least based on this BIA decision, if you're going to make a defective NTA argument, it seems like framing it in terms of claims processing rules is the way to go. And that was matter of Mariscal-Hernandez. Finally, we have Diaz-Rodriguez v. Garland, issued by the Ninth Circuit on December 8, 2022. This case is about the child abuse, neglect, and abandonment deportability ground. But really, it's a giant issue spotter on the categorical approach, statutory interpretation, and agency deference. This case was first discussed on episode 72 of the podcast, when it was before a 3-judge panel. The non-citizen won that round, but Kevin predicted it would go en banc, and unfortunately for Mr. Diaz-Rodriguez, Kevin was right, and here we are. The question in this case is whether California Penal Code Section 273AA constitutes a removable offense under the deportability ground for a, quote, crime of child abuse, child neglect, or child abandonment, end quote. Mr. Diaz-Rodriguez entered the U.S. as an LPR in 1990. Over a decade after his entry, he was arrested and convicted twice for driving under the influence. Now generally, DUI offenses don't make LPRs deportable. But Mr. Diaz-Rodriguez's child was in the car with him. So in addition to the DUIs, he was convicted under Section 273AA of the California Penal Code, a child endangerment offense. DHS brought removal proceedings, alleging that the California offenses made Mr. Diaz-Rodriguez removable under the INA ground for child abuse, neglect, or abandonment. He was found deportable as charged, was denied LPR cancellation, and was ordered removed. To sustain the removability charge, the IJ relied on BIA precedent interpreting the removal ground, which I'll discuss in a bit. After winning his case in front of a 3-judge panel, Mr. Diaz-Rodriguez has now lost his case in the en banc Ninth Circuit. Before delving into the case, there's something important to note. There was actually no majority opinion in the case. What we have is a plurality opinion authored by Judge Ikuda, a concurrence authored by Judge Collins, and a dissent authored by Judge Wardlaw. When there's no majority opinion, the narrowest grounds for the judgment control, and here the narrowest grounds were offered by the plurality. So it's the plurality that I'll mainly be discussing. Again, the question before the court was whether Mr. Diaz-Rodriguez's California child endangerment conviction qualifies as a deportable offense under the INA. That question is answered under the categorical approach, which has 3 basic steps. First, figure out the minimum conduct necessary for a conviction under the California statute. Next, figure out the elements of the INA removability ground, here, child abuse, neglect, or abandonment. Finally, compare the two to see whether the minimum conduct under the statute of conviction categorically satisfies the elements of the removability ground. Starting with the first step, the Ninth Circuit examined the California statute of conviction. In categorical approach cases, federal courts defer to state court interpretations of state law. And here, the California Supreme Court has described Section 237AA as a, quote, omnibus statute that proscribes essentially 4 branches of conduct, end quote. The first 3 branches require the infliction of physical or mental injury or suffering, but the 4th doesn't, and therefore describes the least culpable conduct under the statute. You might have heard me say 4 prongs and immediately thought about the modified categorical approach. But the Ninth Circuit has already held in an earlier case that the 4 prongs are means of committing the same offense, not elements of different offenses. So fortunately for us here, there's no need to go down that rabbit hole. The bottom line is that if offenses under the California statute's 4th prong are overbroad, then the whole statute is overbroad. So the court homed in on analyzing that 4th prong. And here's what the 4th prong of the statute says about who is guilty under the offense. Quote, any person who, under circumstances or conditions likely to produce great bodily harm or death, willfully causes or permits a child to be placed in a situation where his or her person or health is endangered, end quote. Analyzing California state court authority, the Ninth Circuit found that a conviction has 3 basic characteristics. First, the perpetrator had to have a mens rea of at least, quote, criminal negligence, end quote. Second, the act must, quote, have been committed under circumstances or conditions likely to produce great bodily harm or death, end quote. Third, the defendant must have, quote, care or custody of any child, end quote, not necessarily his or her own child. The next question is what the elements of the removability ground are. Again, here we're talking about INA section 237A2E1, which triggers deportability based on, quote, child abuse, child neglect, or child abandonment, end quote. As the Ninth Circuit points out, the right way to figure out the elements of a removability offense depends on how the removability ground is structured. In some cases, the removability ground itself will explicitly define the elements or cross-reference a statute that provides them. But sometimes the removability provision is phrased without providing a legal definition of the elements, and that's the case here. All the statute says is, quote, child abuse, child neglect, or child abandonment, end quote, without defining exactly what those terms mean. But to do the categorical approach analysis, you need more well-defined elements. So that's the question the court turned to next. Now it seems Mr. Diaz-Rodriguez didn't put forward a complete theory of what the generic offense's elements are. Instead, his argument focused in on specific ways the California offense was broader than the generic definition of the removability ground. Child abuse under the INA, he claimed, requires at least criminal recklessness. In contrast, the California offense requires only criminal negligence, a lower standard of mens rea. As to the other two prongs of the INA deportability ground, child neglect and child abandonment, Mr. Diaz-Rodriguez claimed that they could only be committed by a parent or guardian. Contrast that with the California statute, which includes no such requirement. The plurality of the Ninth Circuit held that the INA removability ground does not unambiguously compel Mr. Diaz-Rodriguez's reading of the statute. There's lots of deep analysis, so I'll just give you a flavor of the kind of statutory interpretation the Ninth Circuit engaged in. First, the plurality looked at the text, and mainly dictionary definitions, published around 1996 when the removability ground was enacted. The court provides actually a pretty helpful reminder that when doing statutory interpretation, you've got to look at dictionary definitions that were in force at the time of the statute's enactment. So sometimes that means looking through old dictionaries. And the court actually agreed with Mr. Diaz-Rodriguez that back in 1996, child abandonment could only be committed by a parent or legal guardian. But the California offense could still match the INA removability definition if it met the child abuse or child neglect prongs of the federal definition. And as to those two, the court found the dictionary definitions inconclusive. Next, the court looked to context and structure. As to the INA, it didn't find anything conclusive about the structure that would compel either accepting or rejecting Mr. Diaz-Rodriguez's argument. The court also looked at other federal statutes enacted around the same time. It found some stuff that was harmful to Mr. Diaz-Rodriguez's argument. For example, various civil statutes outside the immigration context that define child abuse to include negligent conduct. It also found various civil statutes that define child neglect to include conduct by people other than the parents or guardians of the child. But still, the court didn't find anything that definitively required it to accept or reject the arguments of Mr. Diaz-Rodriguez. Finally, the Ninth Circuit looked to contemporaneous state law, which it noted is sometimes helpful but not required under the categorical approach. After conducting a pretty comprehensive multi-state survey, the court found no prevailing view among the states as to what constitutes child abuse, child neglect, or child abandonment. There were just too many labels and too much variation among the states to yield any real consensus. In the end, the court found it plausible to interpret the INA deportability ground to include the limits Mr. Diaz-Rodriguez proposed, but it also found it possible to read the federal definition more expansively as well. So to resolve this ambiguity, the plurality turned to a podcast favorite, Chevron. That decision holds that when a statute is ambiguous, courts must defer to a reasonable interpretation offered by the agency. The plurality found the BIA's interpretation reasonable. In matter of Velazquez-Pereira, the BIA held that child abuse includes criminally negligent acts or omissions that constitute maltreatment of a child or that impair a child's physical or mental well-being. And a few years later, after some back and forth with the Ninth, the BIA clarified its decision in matter of Saram. There, the BIA held that a crime of child abuse, quote, is not limited to offenses requiring proof of injury to the child, end quote, and therefore, quote, encompasses endangerment-type crimes, end quote. The BIA, however, declined to say exactly what level of threat was required, saying it would decide that issue case by case, but that acts or circumstances that created a substantial risk of harm to a child's health or welfare are enough under the INA's definition. The BIA also said that the definition provided in matter of Velazquez-Pereira actually applied to the entire phrase, quote, crime of child abuse, child neglect, or child abandonment, end quote, essentially viewing the three prongs as a unitary concept. And the Ninth Circuit found all of this reasonable, joining to various degrees decisions from the 2nd, 3rd, 5th, 10th, and 11th Circuits. And at that point, Mr. Diaz-Rodriguez's case was pretty much dead in the water. Remember, the BIA definition allows for mens rea of criminal negligence, and it doesn't require that the perpetrator be a parent or guardian of the child. And those were the features that Mr. Diaz-Rodriguez argued made the California statute overbroad. So because the Ninth Circuit deferred to the BIA's definition, Mr. Diaz-Rodriguez lost his case. But you knew there was more. As I discussed at the top, there was no majority opinion in this case. Everything I've talked about so far was just the plurality's reasoning. So let me say a few things about the concurrence and the dissent. The concurrence, authored by Judge Collins and joined by Judge Bumate, was actually more unfriendly to non-citizens than the plurality. The concurrence would have held that the California statute unambiguously constituted a deportable offense, without any need for deference to the BIA. The dissent, authored by Judge Wardlaw and joined by 4 other judges, was the opposite of the concurrence. Those judges would have held that the California offense is unambiguously overbroad. Their reasoning was actually different from Mr. Diaz-Rodriguez's. In the dissent's view, the generic definition of the federal deportability ground excludes child endangerment offenses, like the California offense at issue here. Essentially, the dissent looked at the deportability ground and saw a list of 3 different offenses: child abuse, child neglect, and child abandonment, and noted that child endangerment was conspicuously missing from that list. In their view, that omission by Congress was intentional and excluded offenses like the California statute that involve child endangerment. All of this has an important implication. It means that a majority of judges on the en banc panel believe that the removability ground statutory definition either permits or compels an interpretation that excludes offenses like the California one at issue here. And that means that the BIA, or the Attorney General, if you're listening, could reverse existing precedent and adopt a more non-citizen-friendly reading. After all, administrative law allows an agency to choose different reasonable interpretations of a statute, as long as it acknowledges its change in position. And finally, a couple of arguments that the court didn't rule on because they were deemed waived by Mr. Diaz-Rodriguez. The first was an argument that even if the statute is ambiguous, the rule of lenity should have broken the tie in Mr. Diaz-Rodriguez's favor before the court turned to Chevron. The second argument was a retroactivity argument. Mr. Diaz-Rodriguez argued that the BIA's definition of the removability offense in matter of SORAM shouldn't be applied retroactively to Mr. Diaz-Rodriguez's conviction, which predated that decision. But neither of these arguments were presented at the en banc stage, and so the Ninth Circuit deemed them forfeited. Still, both arguments appear to be available in future cases in the Ninth. And that was Diaz-Rodriguez v. Garland.
So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please please check out our Patreon page at www.patreon.com/immigration review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all. And follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.